Thank you, sir.
They can be anonymous.
Oh yeah, and well, they've always had the 1-800-CUT-SMOG number at which people complain, and there is a lot of focus on environmental justice. Their new statewide implementation plan that the AQMD is very involved in, focus on environmental justice matters a lot, and that falls under that category. Absolutely.
That number 11, OCI, is what is OCI?
Office of Criminal Investigation.
Is that just DTSC or is that?
That's DTSC. And so that number was a bit alarming. We haven't seen anything close to that in the past, and we looked at these reports from the past. So we're still researching that. Sorry I couldn't get you a more definitive number of what that 42 million is. It's sort of a big deal, eh? But we think it's an error. All right, let's, a little bit of a graphic. So we're going, I said I wasn't going to talk too much about EPA, I lied. I am going to talk a bit about them because they provide sort of the granddaddy of enforcement processes that many of the local agencies follow. And it wasn't unfortunate for us that the Air and Waste Management Association had an article this month discussing the EPA enforcement process. So we're just going to talk very quickly. Why don't you take a look at this just for 15 seconds? It's a lot of info. I'll grab a brief sip. So at the top, you've got the triggering event. The astute question was asked, just how does all this begin? Citizen complaint, self-disclosure, a record review, an inspection. All these can trigger an NOV for your existing operations or someone discovering that you've had a release into the subsurface. So sometimes an NOV will come about, then EPA will run their penalty calcs, and then you guys will try to settle it. And hopefully you go this route. Let's call this a short route, the simple route, the easy way. And then there's the hard way. They can file that complaint. The respondent doesn't respond to the default order, an initial decision, or you want to fight it out in the hearing, and then you get a settlement that way. My recommendation is always to try to short-circuit the process. And just another lesson from my oil days is I actually saw he wasn't the CEO, he was the assistant CEO for Chevron. And he got all the young environmental engineers in a room, and he said, you guys are all entrepreneurs. Even though you work for Mother Chevron, you're entrepreneurs, you're here to build things. Regulators are not there to take risks with you. And they are not entrepreneurs, they're risk averse. So just about everybody in this room doesn't mind taking on a little risk. And so the courts actually, and this is more Terry's specialty, but what I've noticed is that the regulators are also considered to be the experts. So you can bring on any consulting firm you'd like, anybody with 5 PhDs after the name, and the expertise typically is always relied upon by what comes from the agencies. I know I'm all jumbled the words, but I think you get the gist. It's very hard in court to refute what the AQMD's expert says, what the Water Board's expert says, what the DTSC, EPA down the road. So try not to get here, and try to stay on this path. Is that a fair summary, Terry?
Yeah, and as a matter of law, under the federal and state evidence codes, they're given discretion by the courts because they're the lead agency. And statutorily, they're given the sole enforcement power. So that translates into the fact that they're given the discretion to have properly pursued the matter and to be correct, unless unless you can bring out some sort of glaring error.
Thank you. Now, I'll ask the question: Who's seen this? Okay. It's very nice of you. I've seen about 500 of these, and obviously we've hit the names, but you'll notice a couple things about this. One, that the NOV was issued in May, and then district prosecutors send a letter in November. That's standard, 5 months it usually takes to get your letter. And then it'll be the company, the dates of violation, date or dates of violation, the inspector's name, and then the person signing off. And I want to mention something about the AQMD inspectors. This guy, Jack Nagy, good guy, very thorough, 30 years experience, at least 1 degree. I know he's a chemical engineer. He used to be a refiner. We used to be on the same side of various negotiations because he had a refinery, Golden West Refinery. Again, more locals may know that one out of Santa Fe Springs. Sharp guy. And there are a lot of very sharp AQMD inspectors who know their craft well. And I've learned a lot from them. So don't underestimate them. And then let's go on to a set of questions that the AQMD asks with each settlement letter. And this is really good advice for data gathering for any NOV, for any media. And so some of it is obvious, some of it is not so obvious. So we're just going to go down this list a couple minutes here. The number of operating days, conditions resulting in the violation existed before and after the NOV was served. Now, you can't go back in time, but you can interpret. So what I always have folks do is just look at that violation, just were there any change conditions that will reduce the amount of time in which you were violating? Did the compressor that was having a fugitive emissions leak, was it not operating 3 days prior? Then you repeat the question adamantly. Was it not operating 3 days prior? So you want to limit that time. And obviously you want to reduce the period in which you were violating after the inspector was on your side. So you need to do everything you can to come into compliance immediately. Remember the story about the Fortune 500 company. So when you came into compliance with the rules, number 3 is very important, ASAP. Which actions you took, the more you document the actions you take to come into compliance, the better. Obviously, run a lot of it through your attorney just to make sure that what you are showing to come into compliance with the rules doesn't have anything egregious you shouldn't be presenting. The story I always relay is, again, young engineer. It's amazing how many mistakes I made. We had a guy who was running half of our refinery. Air district inspector was there. I said, "Here, let me just grab the logbook." And I'm showing the logbook to the inspector for the day, thinking he's not going to turn the page. Well, sure enough, he grabbed it out of my hands and started looking at some of the other pages. So control the data that you give to the agency to show what actions you took to come into compliance with the rules. Excuses, mitigating circumstances, come up with as many as you can. Number 5 is self-explanatory. Number 6, go into as much detail as you wish if you're having a bad year. Really, I mean, and mark it confidential, because all these settlements can be out in the open, and publicly available, I should say. We'll get into that a little bit later. All right, here's a document I think you're going to like. I find it exciting. If you get a DTSC or CUPA violation, go ahead and look up this document. It has got all sorts of summaries of the rules that you may have violated and fine guidance and the like. So again, if you give me a card, I'll have to give you the link, and it's a good document. Here is a summary of it. And Terry was talking about the $25,000 per day max that is in the health and safety code. But there's some interesting nuances. Like underground tanks, it's a per day per tank. So don't think because you've got 3 USTs together, you're only going to get 1 violation. Above ground storage tanks, note the difference between the first day and the second day max. And then here's something interesting. For the Hazardous Materials Release Response Program and CalARP, there is knowing and unknowing differentiators, which is not uncommon, but it's a pretty significant change. In one case, 12.5 times. And then, just to show how if you violate one law, doesn't mean you're not violating another and can't be cited under both. You can violate the CalARP and still be cited for the Clean Air Act violations because they dovetail. Is that making any sense? Okay, good. Again, I'm getting a head nod from Ari. And then other things that this document will describe is just what the policy is with respect to multi-day violations, what the policy is with respect to multiple violations, multi-program violations, and supplemental environmental projects. Anybody in the room done an SEP?
Excellent. Excellent.
I'm sorry?
You did an excellent.
I don't even know what that is.
Majority of them.
Okay. Were you happy with what transpired? Okay.
It's expensive.
Okay, yeah, that was my point. And you, sir, I don't know your name, I'm sorry.
My name's Kent Adams.
Hi. What'd you think of the, are you comfortable sharing whether you like
It was
doing the
with
SCP or not?
It was with the EPA, and it was before I was there.
Okay.
I kind of forget the details. I know we had.
What was the, how shall I say that? Was your CEO happy that you did it?
Yeah, well, he was pretty happy with the outcome.
Okay.
Yeah, I mean, he wanted to get it out of the way, get it taken care of.
What I've found is that sometimes SCPs look good for the company, good PR, maybe it's easier to write off, but it tends to be more expensive, just in general. Yes, ma'am?
The best kind of EPA equipment and facility upgrade. That's the best kind of.
Excellent. Now, and as long as the regulator doesn't feel you're getting some benefit unrelated,
But it all works out that way, then it's better than paying.
absolutely.
Well,
If
that's
you
the way
had,
ours was too. It
Okay.
resulted in some upgrades.
can't go wrong.
Yeah.
That's 80% of ours was for upgrade.
Many times you're limited by the SCPs that you can do. And for those who've never heard this term, instead of paying a fine, you can do a project which has a benefit to the environment unrelated to rules you would have had to comply with anyway. And usually the regulators try to get you to do something off-site, usually. But these three folks have negotiated something quite nice. I promised I'd get to the ability to pay, and if you can demonstrate financial hardship, please do so, but do it in a confidential manner and stamp everything confidential, proprietary, and that will typically not be subject to the public records request. And then, believe it or not, if you have a big fine, EPA actually has financial models on how to show financial hardship for the company, and it's pretty involved. So you may want to get your accountant involved with that one. Brief story. I love sharing recent stories. Kathy, one of the experts in our firm, just finished negotiating a settlement with